All right, good day, ladies and gentlemen. We're now delving into the textbook, and just let me give you a reminder of what this textbook looks like and is. It is Criminal Courts: A Contemporary Perspective by Hemmings, Brody, and Spawn. This book right here. So I'm doing chapter by chapter lectures. So we'll go ahead and start with chapter one. And this is, of course, Courts and Judicial Process, CRJS 220. So let's go ahead and start with chapter one. Chapter one, where first the book's broken up by sections. Section one is all about the purpose and structure of American courts. So kind of an overview, kind of teaching of what the importance of American courts. And why we have laws and why we have courts to enforce and interpret laws. So, uh, chapter one is the introduction, law, and the judicial function. Excuse me. Why study courts? Courts do multiple things. For one, they settle disputes and they provide a forum for obtaining justice and resolving disputes through the application of legal rules and principles. So, in other words, they give us I guess, a humane means of settling disputes. So, rather than pulling out guns and shooting people and saying this is my land or you did me wrong, I'm gonna kill you, or something like that. The courts give us a more productive means of settling disputes, where these disputes can be final and be backed by some type of legal enforcement. Courts make public policy decisions. They do that as well. So they set public policy and they make public policy decisions. Policy making involves the allocation of limited resources to competing interests. And that's one thing that goes on in courts, whether it be civil or criminal court. The basic, because even when we go back to the first point of settling disputes, most human disputes are about the allocation of limited resources. You have something, I don't have it, you should share, or I should have a part of it, part of that's mine too. Even going back to us that if you're a biblical person, Cain and Abel, that first dispute, that first biblical killing. It's always about someone having more or getting more of a blessing than another person. So that's essentially human nature. So the court system serves as a means of letting us know what this public policy is going to be when it comes to the allocation of limited resources. Courts also serve to clarify law through interpretation of statutes and application of general principles to specific patterns. What's that mean? Interpretation of statutes. Statutes are what we call legislative made law. We'll go deeper into that later on. But that's when you have a body of lawmakers, normally elected. This is America, so they're elected lawmakers, whether it be on the local level through city council or county commissioners, or whether it be state legislatures or even federal when we talk about House and the Senate. Those bodies meet because they're shaping and they're making policy. They're creating the laws that govern us. A lot of times when they make these laws, they put laws on the black and white of the paper. There's ink on the paper that says what the law is. It's codified. A lot of times within those, the ink of the paper, sometimes it lacks clarity. Courts provide clarity. They give us meaning. So you have this on paper, but it doesn't explain everything, and the courts fill in the gaps. So courts bridge the gaps, and they create that area where there's no definition, or where it's unexplainable. The courts provide explanation, and they give laws meaning. And that's the point of interpretation, or when the law, or when the judicial or court system interprets until it tells us what laws mean. Also, they apply these general principles to specific fact patterns. So when we have these disputes, we have precedent. We have this one law, and we apply it to a fact pattern, and we should get the same result. And that's what. So it's about consistency as well. What is law? Law is a written body of rules of conduct applicable to all members of a defined community, society, or culture that emanate from a governing authority and are enforced by its agents by the imposition of penalties for their violation. Um, I guess a layman's term, or a good, more common means of defining law would be that there's almost like an invisible contract between yourself and myself and the rest of society. It's almost like the rules for living. And living in this society, there's like an unwritten duty to do certain things that help further society and help protect thy neighbor. Um, so it's a contract between each individual and everybody else in a defined community, society, or culture. So these are the rules that govern. This is how we're going to do things. So even laws that pertain to what side of the street you drive on, stop signs. The reason stop signs are places is because you need to stop to let traffic come through. Everyone needs to stop to give someone else the right of way so that no one will get hit. We can avoid accidents and keep us all safe. Same thing with speed limits as well. So we want to be safe. So essentially, you following the law um, is like you're, I guess, following that unwritten. Well, in actuality, is written, but that unwritten contract between you and everyone else. So the law on the books is nothing more than that code of ethics, or that code that applies to us all, and it's how we govern ourselves when it comes to us and everyone else in society. Um, Violating the law creates a dispute or a charge between you and everyone else for allegedly violating this agreement, i.e., people versus defendant. So, in law, of course, that's why it says the state versus, in North Carolina at least, the state of North Carolina versus this defendant. What that means is you've now violated this code, so you're essentially coming before the people. Everyone, this code you violated was the code that was kind of created in the interest of everyone in society. So when you break a law, or when you are alleged to have broken a law, you're brought before the people, your peers, to say either why you did it or that you didn't do it, and that they have to prove it if they're saying you did do it. But it's all about you and your duty to everyone else. So, we're going to talk about some early law here. We're not going to go very deeply into it, but we're going to talk about the Code of Hammurabi. Hammurabi was a king of Babylonia who lived from 2123 to 2081 BC. So well over 2,000, well over 4,000 years ago. So the Code of Hammurabi was long acknowledged as the oldest known written code of law. It talked about, or it concerned sexual behavior, property rights, theft, acts of violence. It forbade retaliatory acts and vigilante justice. Justice was only exacted by the king's agent. So it took that whole concept of having justice, or getting justice by your own means. There was a code and a way you did things, and the king and the government was what they were the only body that could get the justice for you. But they did go, it's old school, so it went off eye for an eye. You steal something, you get your hand cut off. You kill someone, you die. But that's how that was the Hammurabi Code. That's the oldest known body of law, written body of law that we know about. We won't talk about it much. We won't be really tested on it, but that's just to give you a historical context. Laws essentially keep they keep society. They make society livable. We don't want a land without laws. We don't want a land with too many laws. Then we're no longer free. But we don't want a land without any laws, because we need to know how to govern ourselves. We need to agree on the code of ethics or the code of governance. So two opposing perspectives on law. You have what we call the consensus perspective, or the consensus point of view, and then you have the conflict point of view. They're sociologists, and those essentially those are people that study social behavior and interactions. But they're social sociologists who study law as a social institution and its function as a social control mechanism. And they tend to view it in terms of two broad perspectives, as I've just said. That first perspective um, is the consensus view, or what we call the consensus theory. Consensus theorists emphasize how society is structured to maintain its stability and view it as an integrated network of institutions such as family, school, church, the economy, and government. This network of institutions functions to maintain social order and the system as a whole. So essentially, it's saying that people are good. It's kind of a optimistic view that people govern themselves through these institutions, and laws kind of are shaped by these institutions. Social stability is also achieved in the consensus view through cooperation, shared values, and cohesion and solidarity that people feel by being a part of a shared culture. The other view is what we call the conflict theory. Conflict theorists consider society to be composed of individuals and groups with sharply different interests and to be characterized by conflict and dissension. People and groups everywhere, they maintain, seek, and maximize their interests. Um, because resources are limited, conflict between different individuals and groups is inevitable and continuous. Stability and order that consensus theories see is only temporarily maintained by coercion rather than consensus. So, what that means is the ability of more powerful people and groups to impose their will on less powerful. So that is, so the consensus theory is good, I guess, in theory, um, but in real life, when we look at things in a practical way, and the things way, and we look at it through an actual lens, of actual living. Um, I would say there's a little bit of consensus theory going on, but there's a lot more what we call conflict theory that applies. People are out for themselves, and here and there, people will be on the same page, but for the most part, the laws and governance is determined by those in power. So that's all that says. Okay, what is the relationship between law and justice? Justice is what is fair and right based upon the law. Equity is a term derived from the Latin word for just, and it refers to remedies for wrongs that are not recognized under the law. So there's a slight difference between justice and equity. Justice is usually based in the law. What's on the paper. This is what the law says is right, and we all know that sometimes there's a matter of fairness that maybe would be outside of the penumbra of what the law says is right. Sometimes you have the law on the books, and the law in the system, and you have the law of the streets, as they say. So equity would be that law of the streets. What the common person would see is just being fair. Um, so equity is what is fair or right outside of the law, based on society or community norms. It may not be right to fight someone. Even if they, say something bad about your mama, you can't just haul off and punch them by the measure of justice or the law. But when it comes to equity, most people would say, "What'd you say about my mama?" Well, if he said that about your mama, he deserved to be punched. It's not necessarily right legally from the justice standpoint, but in equity, the way we think as a society, that may be something. Sometimes conduct is allowed or justified based on equity as opposed to justice or law. The rule of law. Um, there are three elements of the rule of law, what they call them, the irreducible elements of the rule of law. One, it requires a society to recognize the supremacy of certain fundamental values and principles. So you have to have a society, whether it's the country as a whole, whether it's a small community, even when you're making household rules or law, you have to have some type of either micro society or macro society as a whole, but you have to have a society that recognizes certain fundamental principles and values. Then two, these values and principles must be committed to writing. That means it must be codified. In other words, these are the rules and principles that apply. You've been put on notice that this is how it goes down in this community. And then three, a system of procedures that holds the government to these principles and values must be in place. So we have to have procedures, and we have to have a means of dispute when it comes to these standards that we have. The system of procedures to hold the government to its principles is best articulated by the concept of due process. So if you know you have to have a system that can enforce, not only enforce the law, but in situations where the system claims that someone has violated the law, the system must also give you a means of either challenging the law or defending yourself against an alleged violation. If someone has alleged that you violated the law, you have to have what we call due process to defend yourself. Due process is procedural justice that is due to all persons whenever they are threatened with loss of life, liberty, or property at the hands of the state or of authority. The hands of authority. So that's what when we say due process, that's what that means. So in other words, there has to be a procedure. If you're going to take something from me, if you're going to accuse me of something, if you're going to take my life, liberty, and property, then there has to be some solemn um, procedure, some hearing I have to go to before you take it. You have to give me a chance to defend myself. That's what we talk about when we talk about due process. It's just that when we say due process, we say that certain types of justice that is due to all persons, and the process itself is just procedure. So to take something from me as the government authority, there must be a procedure that is due to everyone that is accused to have violated some law of some sorts. So, um, talked about justice, the law. The book talks about justice, the law, and Packer's models of criminal justice. We're just going to talk about two of those models, or there are two of those models of criminal justice. There's the crime control model, and this views suppression of criminal conduct as the most important function of criminal justice system. In other words, all about suppression of crime, making sure people don't commit crimes. The primary function is to control crime by apprehending, convicting, and punishing those who violate the law, and emphasizes efficiency and finality, which is achieved through informal, adjudicatory procedures. So that's the crime control model. So it's all about law enforcement doing their jobs, preventing crimes, and law enforcement having more discretion and more decision making in stopping crimes and leaning more towards that. So it's almost like you're trustful of of the law enforcement and judiciary, and prosecution. Then you have the due process model. And this is a view protecting the rights of individuals as it views protecting the rights of individuals as the most important function of the criminal justice system. So it's more about the due process right. So um, rather than being about preventing crime, it's more about protecting those who have alleged to been who have or alleged to have committed a crime and making sure their rights are protected. It emphasizes reliability, which is achieved through formal adversarial procedures. So, in that due process model, rather than the trust being on law enforcement, the trust is placed more on the system to make sure um, that people get a fair shake in the system. So that's what that's about. Um, so let's see. Let's move on. Judicial functions. What are judicial functions, or what are some of the functions? The function of the judiciary or court is they provide a forum to settle disputes, either in civil court or criminal court. Two, they make policy decisions that politicians may be unwilling to make for fear that they may not be reelected. So the judiciary or judicial functions, in those functions, they do a lot of stuff that's hard. Um, the court has to make hard decisions every day, and sometimes hard decisions are hard to make by someone that has a political dog in the fight, and they don't want to lose. They want to get reelected. But when from the standpoint of the judiciary, they're just making a decision based upon the facts, so there's less fear. Now, to that, I will add that judges, at least in this jurisdiction, in North Carolina, um, on the district and superior court levels, on the trial level, they are elected officials. So there is always going to be some level of, well, what I'll say, even the judiciary can sometimes be compromised because they do have a political dog in the fight. They just have less of a political dog in the fight than a policymaker, someone that's made the policy, what we call a legislature, someone in that position, in different position. The courts also serve to clarify the law through interpretation of statutes and application of general principles to specific fact patterns. And we've kind of talked about this before. Courts are reactive, that is, courts do not initiate cases, but rather serve to settle controversies brought to them. So the court doesn't go out looking for trouble. Trouble always comes to court. Now, next we go to how judges make law. They give written laws meaning and definition through practical application. So you have a written law, and now you're applying the law to a set of facts. Someone has now been accused of violating this written law. So the court now has to give that written law meaning by applying it to a set of facts. Someone is accused of doing something. They did it this way. They went this way. Now, how does this law that's on paper apply to that? What else has to go into our thinking when we decide whether or not a person is guilty based upon this written law? The facts are brought to the court and give guidance. The facts are brought to the court for the court to give guidance as to how the law is to be applied to the facts. So that's how judges essentially make law. Law may be made and may be on the books, but the judiciary and it gives through interpretation, it gives the laws meaning and explanation, and it gives us it gives us instruction on how the laws to be applied to situations. So the development of the common law system. So we talked about the Hammurabi Code, which is one of the oldest legal codes or written codes that's ever been found. But then we talk about the English common law system, and that's essentially the law that made it from America. So a lot of American law is based in English common law. So you had old English court-made or defined law that was reduced to writing. That's what the common law is. It's old English court-made or defined law that was reduced to writing, circulated, and summarized. So what you had is the courts in ancient England settling disputes, making decisions, and saying, well, this is the law. Now that we've settled this dispute, this is what the law will be regarding this same fact pattern. If something happens similar to this, this is what the law will be. And they codified it. They defined it. They say what is legal and what isn't legal through the courts. Precedent. Decisions of another court or judge in prior cases that the judge trying or reviewing a case will rely on as a justification in forming his or her decision in the present case. So that's what precedent means. So precedent means if there's a precedent that says in this same fact pattern, this is the rule of law. That means if something comes up in the future and it's the same fact pattern, I'm going to apply that same rationale that was already set in place. That's precedent. Precedent is what keeps courts not just reliable, but it keeps them reliable by keeping courts consistent. You almost want to go into court, and it makes it easier for me as a lawyer. If I can hear a set of facts, my client can tell me something, I can say, well, you're probably going to get charged with this, and this is how it's going to go. So I'm able to be more effective as an attorney, and even whether I'm on the prosecuting side or the defending side, um, precedent helps us, and it helps the court make decisions, and it helps us realize how we're going to now attack a case, or for prosecutors how they're going to prosecute cases. So precedent is very important. Stare decisis is kind of what the institution of precedent is kind of based off of. It means let the decision stand. If there is a prior decision on a legal issue that applies to the current case, the court will be guided by the prior decision and apply the same legal principles in the current case. That's all precedent and stare decisis mean. And that's how we keep it consistent. Now, that doesn't mean that something old or old precedent can't be changed. It can be changed. It gets changed by being challenged. When we challenge a precedent and say, well, that's not right, I believe it should be this. And that's, usually that, goes through the process of appeal. And then the Supreme Court, or whatever the highest reviewing court is in whatever jurisdiction, it may not be federal, it may be state, they determine once and for all whether or not that precedent is going to now be adjusted. That's one thing about laws. When a lot of laws are made, whether it be common law, even the Constitution itself of the United States, which is what constitutes our government, when it was made, times were different, right? There's a lot that's changed between 1789 and present, right? Um, so there were a lot of certain laws that applied then that may apply now, but because times are different, technology is different, how we live on a daily basis is different, the laws would also have to change. So laws are elastic like that. They have to stretch and change to the time. So just because there's a precedent doesn't mean that it's going to be that way forever. Precedent can be changed. It just has to be changed through the process of appeals. Okay. Judicial review. Judicial review is the power of the court to examine a law and determine whether it is constitutional. This power of judicial review, it was essentially created through the case of Marbury v. Madison. It was an 1803 case. This was the case that gave courts power as a branch of government, essentially saying that, we'll talk about 3 branches of government later, but the judiciary is what we're primarily talking about now. So the most important function of the judiciary is what we call judicial review. It allows the courts to look at the acts of, either an act of Congress or a law, or even the actions of the executive branch or the president, to determine whether acts and actions of other branches are constitutional. So that's the main power of the judiciary, and that's judicial review. This power was expanded to not only give the court the power to examine laws, but also acts of the other branches, as I said before. Kind of repeat myself. Next, we talk about the role of courts and the criminal justice system. Adjudication is one role. Adjudication means to process defendants who have been arrested by the police and formally charged with criminal offenses. So that means part of the judiciary, or the role of courts, is to process and move people through. I call the court system a factory, right? And you have to get something at the start, that's in the beginning of the factory phase or the making phase, and pass it through to other phases, the other stations, and at some point it's going to come out at the back end, either guilty, not guilty, or whatever. But it's essentially, think of the court system as an assembly line. So that's what adjudication means. It means you're processing people through. Oversight. Another role. The courts, particularly appellate courts, provide oversight or watchful eye, not just over the lower courts, but over the criminal justice system in general. So that's the important thing about courts. They adjudicate matters, and they kind of are that watchful eye, and giving oversight to the actions of law enforcement, and even trial court judges in cases in lower courts. So that's an important thing. So you talk about adjudication and oversight. So those are the main I guess roles and functions of the criminal justice system. So that takes us through chapter 1. Make sure you are reading the material. As you hear me say ad nauseum, that reading is is your job. Me giving you these lectures, that is not your reading. There's a lot of knowledge I can't sit here and read to you. To lecture. I have to, shorten this stuff. I have to make it, I guess, more palatable, and more digestible. And like I said, I create my own outline that I teach from, so I can kind of short form and give you guys efficient lectures on this stuff. So that's chapter 1. The textbook, what I'll